I'm welcoming everyone to the last session where we're going to talk about legal challenges in general and also how COVID impacts on the asylum process, especially in Germany. But I'm going to announce some of our housekeeping rules. So we are going to have about 40 minutes of discussion with my two guests, who I'm going to introduce in a moment. And then we'll have time for about 20 minutes of a question and answer session. And the people present can submit questions anonymously through the Zoom chat function, or also if they are joining us on Facebook through the Facebook comment session. But I just wanted to say that we won't be necessarily able to address all the questions given the time constraints, and also that we will not be able to do a case-specific approach, but maybe if there are questions, we'll try and see whether there are things that can be generalized, even if it comes from an individual case. And it's, if people here are looking for conference queereuropeanasylum.org and find some links. And also, if you go to the website of the project that Lilith was representing earlier from LSVD Queer Refugees, there's a link to about 90 places in Germany where you can find counseling, and there is a link from Ardis in France that has a mapping of organizations across Europe. And people can follow us on Twitter at Queer Euro Asylum and give comments with the hashtag COVID-19 Queer Asylum. So I'm very happy today to welcome Alva and Jonathan to this last session. We were planning to also have a judge join us today from administrative court in Germany, but unfortunately for us, some of the courts are starting to work again in a more regular fashion. That person had to cancel for this event, kinds of discussions. So Alva Träbert is a feminist sociologist and a gender historian that's providing counsels for queer refugees. And she also is helping coordinate a statewide training program in the state of North Rhine-Westphalia, training counselors from different kinds of offices around issues affecting queer refugees. Nice to have you here, Alva.
Thank you for having me.
We also welcome Jonathan Leuschner, who is an immigration lawyer based in Frankfurt. He studied in Cologne, Switzerland, and also did some work in Brussels and Brazil. And he has a lot of experience with asylum law and the issue of family reunification. And he has done a lot of work with unaccompanied minors, where he's actually published some handbooks, and he has worked with LGBTQI refugees in the Frankfurt area. So I welcome also Jonathan.
Thanks for having me.
Yes, and my name is Philipp Braun, and currently I'm a volunteer working with queer refugees with LSVD. And previously, I served as co-secretary general of ILGA. And I just wanted to tell people that if they are interested in the asylum process in Germany for queer refugees, that you can go to the LSVD website, and we have an extensive listing of court cases on individual countries, but also on the judgments on some of the more technical issues. And we also have a legal guide that's quite up to date on issues of queer asylum. So if people are interested. And also we have prepared a one-page document that's online on the website for the conference where we explain some of the peculiarities of the German asylum system. And that's something that people can reference, but I'll also be pointing out some of these issues. So today we are going to look at the issue of how the trials work. We're going to look at how NGOs work with lawyers, and we're going to especially look at the recent court decision by the German Constitutional Court on the 22nd of January around whether it can be required for LGBTI people to be hidden if they would be sent back. And we're going to finally talk about some issues around the current situation with COVID-19. But I just wanted to start with a few words that we are looking at asylum law as it applies to queer refugees within the German system, which is again within especially EU legislation, but also the European Convention on Human Rights and the Geneva Convention. So, so a lot of the German law derives from these things, but there's also some very specific rules that impact if people decide to take a negative decision from the asylum agency BAMF to court. Because we have 48 first-level courts and 15 second-level courts, but it is extremely difficult to challenge a negative decision from the first-level court. And this is especially true if the court did not find the person taking the case credible, or if it is about one issue of fact. So that makes having good representation all the more important. And also that for political reasons, because that's how the lawgivers in Germany decided to have this, there is no case law on the questions of fact. So for example, the question for Syrian refugees, whether someone facing the draft gets subsidiary protection or refugee status, that is not handled in a unified way across Germany. It actually really depends on where people are taking the case. So I would like to start just talking about how people who are plaintiffs in court, how they can go about presenting evidence in the trial. And some of the practical questions, and I will just start with the first and ask Alva or Jonathan to come in. How some of the information people might provide gets perceived by the court. So for example, if they have photos about relationships or having been to a pride, if they have put this on Facebook, if they have chatted with someone on WhatsApp, how this does get perceived by the courts. So maybe Jonathan and then Alva wants to come in.
All right. Well, basically, like you just said, Philip, many things can be evidence. Chats, Facebook posts, witnesses, NGO statements, of course, expert opinions. If and what evidence is presented depends very much on the individual case. If, for example, there is no doubt at all about someone's homosexuality, it is not absolutely necessary to submit evidence at all. So you really have to look at the individual case. If there are still crucial points, if there are still open questions, and then should decide whether it is necessary to present evidence or not. The way in which evidence is handled, well, I would say it varies very greatly. There are judges where where you really get the impression that even the best evidence and a completely consistent set of facts are not enough to win the case. And well, as you can imagine, those are really frustrating experiences because you're sitting there and you get the feeling that the whole procedure is very unfair and arbitrary. So yeah, this is frustrating. But fortunately, not all judges are like this. And in cases where you have the impression that there is still something controversial, first of all, and that the judge might be open to your argumentation, it is of course a good idea to look for evidence and to present it to court. And well, if you decide to present evidence, I think it's the most important thing is that it fits the story that was told before, and that that you don't produce any contradictions because of the evidence. Well, to be honest, sometimes that happens, unfortunately. I might give an example. Let's say we're talking about the persecution of a homosexual man, and in order to show the court that he already lived out his homosexuality in his home country, he submits transcripts in which, or chats, I don't know, whatever, in which he talks about regular visits to gay clubs in his home country. Then an unfair judge could say, oh well, it's not so bad in the plaintiff's home country after all, because there are gay clubs, obviously, where he can live out his homosexuality. But what I'm trying to say is you have to be really careful, and you have to check whether it is absolutely necessary to present evidence regarding one specific point.
Okay. Thank you, Jonathan. Alva.
Yes, well, not surprisingly, I agree with everything you said. And I would like to add that in my experience, it's really important that whatever evidence someone submits when I'm helping someone prepare for a trial is that we make absolutely sure to surround that piece of evidence with the appropriate context, because otherwise a court does not know what on earth this is. So for instance, I might have a client who says, well, you know, I wasn't believed before that I had tried to live openly or that I had any kind of queer life. So I have this envelope of printed off photographs from a pride parade. And you can see there are people, you know, in a parade, and they're wearing colorful clothing, but that's it. So obviously, understandably, a court will then say, okay, you went to a party? When is this? Where is this? Why is this? What does this prove? So it's really important to be able to supply the context for a court to understand when this was, what consequences this might have had, and what the cultural and social and political and legal context was of that event. I think the same is true for medical and psychiatric reports that can be really damaging if prepared badly, and really helpful if prepared well, because obviously they're not supposed to be about proving someone's identity, but with a lot of my clients, I often work with colleagues from another organization who work in documenting physical and psychological injuries, trauma as a result of torture. And it can be very, very impactful for a court to have psychological and medical professionals jointly explain that someone's injuries and someone's trauma are actually very much consistent with the kind of experiences that someone is presenting. And that can be very helpful to balance out maybe someone's inconsistency in a timeline sense or with some of the details. So I think it's really important to provide context and to be very strategic in how you support someone's account in court.
Thank you, Alva. Yeah, and then related the question whether it makes sense, and also who can be named as a witness. So, you know, whether if someone here is in a relationship or has friends who are in the LGBT community or people who work with support groups, how that gets perceived. And in this context, this is more a question for Jonathan. When groups like where Alva works and others write statements that are presented to the court ahead of time, whether there are things that are specifically helpful or, you know, what could be mistakes. So if you could address those two questions, and maybe Jonathan also address the question about these statements.
Yeah. Well, I'll start with the one about who can be witness.
Can you get a bit closer, maybe, so that you're...
Yeah, I can try to shout.
Yeah, so it's a bit, yeah, thank you.
All right. Better now?
Yeah.
Okay. Well, about who can be witness, basically anyone. But again, like I said in the to the first question, it is I think it's very important to check if the witness could give information about a question which is still controversial. So once this really important question well is answered, you have to look if there are if there is a good witness to that you can present to court. And well, what is clear, I think, is that in cases where internal processes are involved, so especially when it comes to religion, to sexual orientation, it is of course very helpful if there is someone who can credibly report that the given information, the information given from the plaintiff, is correct. So of course, a priest or pastor who confirms that someone goes to church every week and is intensely interested in religion is a very good witness, and is as helpful as, like you said, a partner who confirms that he or she is homosexual and in a relationship with a plaintiff. So well, that's for sure. But again, I wouldn't present a witness in every case. You have to look if it's necessary first, and then you have to look if there is someone who can report in a good way the still can answer the still open question in a good way.
Thank you, Jonathan.
Oh, and the second
part. The second part, yeah, the what?
Yeah, that's more difficult. Well, I think it's what is quite obvious is that written statements of NGOs shouldn't contradict what the plaintiff said. That's really obvious, I guess. In the ideal case, the NGO confirms with its statement once again, or the first time, what the plaintiff has already said before, and then, and that's maybe the more important part, describes the special need for protection of the person concerned. By doing that, the NGO should use its specific expertise on the issue on which it is working to assess the individual case. That's I guess how you can describe it. And by assessing the case, tries to describe to the court how dangerous it would be for the plaintiff to go back.
Thank you, Jonathan. Yeah, and maybe before I hand over to Alva, in my asylum procedure, if people are still in the process of applying with BAMF, that it's actually not advisable to bring a written statement of the history if they go for the oral interview, because the risk is very high that there will be a contradiction between what is written and then what gets asked. But if we're going on to the court proceeding there, the situation is slightly different.
Or if I may add that, especially when you got minors and you're sending the asylum request in written form. Sometimes sometimes people would send their whole story in a written form before they go to the interview, and I don't think that's a good idea either.
Yeah, thank you. Alva.
Yes. Okay, let's see if I can remember what all those questions were. So your first question about which persons can or should be named as witnesses. I agree with Jonathan that it's very much a strategic question. In my experience, definitely a witness should be a person who is going to be able to confidently speak on the issues that this specific court meeting is actually pertaining to. But it can also be very, very helpful to have someone who maybe isn't confident enough to speak, just to accompany someone to court. So I think it's equally important to think about, there might be these 3 or 4 people in someone's life who all are available to come along to court. Which of those people are most useful as witnesses, and which of those people are most useful to present visibly that this person does have a support network, does have connections, does have links to the LGBTQ community, and also just to help the plaintiff just get through the court session. Because being able to look at someone who's there with you, even if you know they won't be able to speak, can mean a huge amount to calm someone's nerves, and we shouldn't forget about that. In terms of written statements by NGOs, I suppose there are different types of statements. So one of them would clearly refer to something along the lines of the country reports that the LSVD often writes. So a really detailed assessment of international human rights reporting on the situation of LGBTQ people in a certain country, and kind of evaluating what is known, what is unknown, what are the dangers. And that's definitely something that I would organize for my client. But in addition to that, what I would prepare is a statement that ties that and meshes it with the individual story of the person. So I would be very careful not to add too many details, because again, there's a risk of being any kind, contradictions or confusion. But I would make sure to rebut every single point that was made before, of the basis that someone hasn't been believed before. So I would be able to kind of refer to the country report and then explain, these are the exact points that someone in the first instance with BUMF has misunderstood. You've misunderstood this specific cultural context. You've misunderstood this issue. Actually, this type of story, this type of experience is something that we see a lot. And to be able to bring in my specific perspective that comes from seeing a lot of people going through similar stories. So I think, again, it's about making the story as clear as possible by providing the necessary context in a very concise way. I think that, what was your third question?
2 questions.
Yeah, the third point that you both also came back to was the question about having written statements in advance of an interview. And maybe I would like to just add that, yes, that is definitely dangerous, because after the interview, the person will definitely not be taking that paper out with them. It will stay with BUMF, and it will be compared exactly to the verbal account that was given. So one example that I recently had in one of my counseling sessions was a young person who was, he just turned 18, and he was terrified, and he didn't even have the option. He really couldn't remember what he was going to talk about, because he was so scared and so traumatized, but also he didn't even have the option of writing something down, because he couldn't write, like a lot of my clients can't write. So we actually practiced making little pictograms, and we made little visual notes for him by drawing little scenes. So they were really helpful in helping him to remember what the main points were that were really important to him. But they were also so unspecific to someone who didn't know the story that they didn't really carry that additional risk of leading to contradictions, because someone else would not really be able to infer as much meaning as he could. So that might be a way to get around it if it's really important for someone.
Yeah, and maybe we could just also point out that, at least in the German legal context, if a person is named as a witness, that person in general would have to leave when the plaintiff is getting questioned. So that they're also going to look at whether how these stories mesh.
Yeah.
Yeah, and then I to bring this part to a close, I have two further questions, and one concerns the whole issue of interpretation, because I mean, also in the written statement we have provided online, I mean, we point out that a lot of times people don't have the trust when they go for the interview with BAMF, and if the translator is prejudiced, and you know, we could all probably give some examples of things we have heard that can happen. But also when you are going to the court procedure where the interpreters are, you know, sworn by the court, can someone who is there accompanying the plaintiff or the plaintiff himself point out if they see that there are, you know, major errors of translation being made, especially around LGBTI terminology? That's kind of one question. And then to round this up, whether you see something that the plaintiffs themselves can do to try, quote unquote, influence how this whole court procedure goes. I mean, so maybe Alva can go first, and then come to Jonathan.
Okay, well, obviously, fear and issues around incorrect translation, sometimes by accident and sometimes deliberately, is a huge factor in both asylum interviews and court cases. There are a lot of translators, even if they're professionally qualified, that aren't confident using this specific language around LGBTQ issues. And often it's not, you know, it's not because of bad intentions. It's genuinely that they lack positive words to describe someone's identity, or even terms. And since you can't really influence which translator you will have in a court case, I think there are several strategies that you can work on with a client ahead of time. One of them would be that even if a plaintiff doesn't speak German to any kind of relevant degree to be able to, well, they need a translator, so they do not speak German. It's still possible to practice saying a few German phrases, such as the phrase, "There is a problem with my translation right now." So to give someone the ability and the power to be the person to raise that issue themselves as soon as they notice it. And the other thing is that if someone knows that they will need a translation to talk about their identity, and maybe they're either worried that that will be mistranslated, or they only have words in their first language that are negative, it's always an option to give a statement and to just replace those words with German words. It's completely, there's no reason why that wouldn't be possible. So you can always, if there's something that you want to absolutely not have misunderstood, it's always an option to prepare that specific vocabulary in German. And it doesn't have to be whole sentences. It's enough to just make sure that you get that word across.
Thank you. Jonathan.
Pretty much nothing to add. No, honestly, that was it. I think it's, well, of course, if the plaintiff sits there and notices that the translator is making mistakes, noticing errors in the translation, then of course he or she should point it out immediately. He or she can send a short note to his lawyer, her lawyer, and it will, or if he or she feels better with it, he or she can tell the court directly. To be honest, I don't care too much about how the court gets to know that there are mistakes in the translation, but more that the court gets to know it very fast, immediately. Because there are few things that are more annoying than standing in front of the court with a client and being told that the interpreter was substandard. That's why it is so important what Alva said. It is very important to prepare the clients, the plaintiffs, that they should point out immediately when something wasn't translated well. About the second part of the question, with regard to the supporters in the room, in the courtroom, I see it a bit. Well, I see it rather differently. They are not involved in the process, and therefore cannot directly influence it. Because interjections are not really welcome by most judges, I don't think that's a good idea. You can always try to send some signals to the lawyer, to the plaintiff, but to shout from the back, usually it goes down very fast in the room. So that's not a really good idea. And about that, I wanted to add a little thing to Alva's statement before. Of course, it is very good to bring people to the court hearing, people who you trust. But at the same time, in my experience, it is very important that there are only people who you trust. Because that happens as well. That people tend to bring a lot of friends because they think they feel more secure when two friends are sitting in the back, or half of the church community, I don't know, and then they are like frozen because they can't speak freely anymore. So it is very important that the people you bring to the court yourself are people whom you trust completely.
Thank you. Yeah, and I wanted, before I come to the next question about the experience with lawyers, where I think for the moment maybe Jonathan will step aside, since it's kind of hard to talk about his colleagues. Yeah. I wanted to tell a little anecdote, because I also work here in a church with refugees, and when we had a really pretty outrageous court case that we're still trying to challenge in the second level court, I talked to someone who is retired, who was Amtsrichter, someone who, you know, takes questions of guilt or not guilt, if there's a crime and who's guilty, etc. And he just said, well, why don't you just go and appeal it? And I was trying to explain to him how difficult it is to appeal, that there are very, very, high burdens, because for an Amtsrichter in Germany, it's clear, if you don't like what he's doing, you just go to the next level. And if you can afford it, you can try, even go all the way to the Bundesgerichtshof perhaps. But in asylum law, this is much more difficult. And this also means that it is even more important to have good legal representation, because if the lawyer in the first instance, does a really terrible job, then it's very, very difficult to go and raise issues he or she didn't raise in the second level. And we've already had a question, how we can deal if we have the feeling that the judge has a problem dealing with these issues, or even, might be homophobic, but it's very, very difficult to challenge that because the judges are independent, and to, challenge court decisions is quite difficult. So I wanted to ask Alva, how much you and maybe other people you work with have had the experience that someone, got a negative decision from BAMF, took it to court, and then it turns out that the lawyer taking on the case never did a substantive written statement of claim. And then you go to court. What your experiences there?
Yeah, I suppose that's not just one straightforward answer. Yes, a huge majority of the people that I work with arrive at a time when they have been rejected after their interview, and or at a later point down the line. And often it's actually very hard for me to work out what exactly happened with their legal representation in first instance, because a lot of people don't really have all their documentation in a neat folder to present to me at all. So it's quite chaotic trying to figure that out. It's also sometimes hard to figure out when I know someone is preparing for a court date, and I know they have a lawyer, and my client explicitly wants me to speak to the lawyer, to support the written statement of claim. it's very hard for me to know whether that lawyer is actually taking anything I'm saying into account. And to be honest, some lawyers are amazing. They're really engaging, they're very motivated, and they're really, really eager to do the best job they can. But there are also lawyers who never call me back. They don't answer the phone, they don't answer my emails, even though I'm sending them, you know, written statements by my clients saying, you know, I'm also getting counsel from this person. I really want them to be able to submit a written statement. Please speak to them about my case. Please liaise with them so that you can prepare me the best way possible. And I just never hear back from people, which I think is outrageous and also really not very smart, because I think sometimes people really underestimate the usefulness that a specialized NGO statement or you know, someone being able to prepare a client for a hearing can have. And it really makes it hard for me to support a client, because sometimes I'm just not entirely clear what exactly is happening in a court case right now. Because clients are obviously, well, I don't know if that's obvious, but they're often not really able to tell me exactly whether something has been submitted yet, or whether they have a specific date for something coming up yet. They have a vague feeling of dread, and they will tell me, you know, my lawyer said there is a specific date coming up, but often they won't be completely clear on what that date is. So if someone just doesn't want to talk to me because they maybe don't think that having an NGO supporting a case is particularly important, because they think they can just handle the case without that, it's just very difficult to work together. And it's sad, because these are obviously cases in which clients have specifically asked us to do this. And so actually I would quite like some advice on how to convince lawyers that working together can be really beneficial.
Very nice question. I don't know. I don't need to be convinced. Well, I think it is very helpful. That's why it is really difficult to give an answer to your question. Sometimes it might be possible that colleagues are too busy. I don't know. I don't want to blame any colleague right now. And I don't know the cases you were talking about. So it's difficult to say something about that. In general, I would say that it is, for a lawyer, very helpful to have an NGO by his side, his or her side, an NGO with specific experience in regarding one point, one specific question, well, having help. So yeah, well, I'm at your side there. I think it's not really understandable why a lawyer would not use the experience and the expertise of an NGO.
Maybe one thing I would also like to add is that there are a lot of cases in which people didn't actually address their sexuality or their gender identity in their interview, often because they at the time didn't have the necessary information pertaining to their rights. They didn't know it was an option, or they were afraid, they were ashamed. And so they're actually, they're appealing a decision, and they have legal representation, but that legal representation doesn't actually know why they're appealing it. So there are frequently situations where I have a client that I've known for several months. I've seen them regularly. I've been speaking with them about what they've experienced, what their current challenges are, supporting them in adequate accommodation, dealing with violence protection, everything kind of outside of immediate legal issues. And then I'm the person who actually is supposed to call the lawyer and tell the lawyer what this is actually about. So sometimes I think there are also situations where lawyers actually, they literally don't even know why this NGO is trying to talk to them yet, because they don't know what the client is trying to tell them.
Okay. Yeah, thank you. Well, I think we need to move on to another topic, but I really wanted to stress, I mean, on top of the experience that Alva has, that she doesn't get feedback if there's input being provided. I mean, we have seen several cases where lawyers we worked with really did not, or where we got to know more about the case later on, that lawyers really went to court without really doing a proper justification within the asylum law of why this person should get refugee status, and then just kind of hopes to go into the court and, you know, convince the judge. And that's sometimes very, hard to believe.
Well, but
And again, it's really putting the client at risk, because if, arguments haven't been made, also then perhaps not in the oral court hearing, then it becomes really difficult even for an experienced lawyer to take on the case for an appeal. Jonathan.
Well, maybe we can use this discussion. Maybe some law students are watching. We still need more migration lawyers, and maybe that's one reason why lawyers don't answer to emails, because there are still not enough lawyers working in this field of law, and those who are working in this field of law are really packed with cases. So that's a good opportunity to tell people, go into migration law. It's a really interesting field of law, and you can do good stuff.
Okay, thank you, Jonathan. Yeah, so we'll move on to the next topic, which in a way is related to the first panel this morning, when Nunu was talking about the European Court of Justice XYZ case, because on the 22nd of January, the German Constitutional Court did a decision on an application from a bisexual man from Nigeria, where in that specific case, they did not take it on as a constitutional challenge, saying that that had not been argued sufficiently enough. But interestingly, they took the opportunity to write into this decision that it would be arbitrary for an administrative court in Germany. It would be per se untenable and arbitrary if a court would require someone who's LGBTI to hide their identity if potentially they were sent back to the country of origin, which on some level is only reaffirming XYZ, which has that language. But what is very interesting, that one of the challenges is in bringing a challenge to a first level court decision, that there are only very specific kinds of other cases that you can cite. And if you look into the German asylum law, it does not list the European Court of Justice. So now being able to directly reference the German Constitutional Court was a major breakthrough. And for those of you who speak German, if you go to the one sheet we provided, you can find a summary of this decision at Asylnet, and I'll actually post it on the chat window. So I would like to ask Jonathan and Alva how this impacts, because we have cases from places like Morocco, Pakistan, Algeria, where there is differing court cases, where administrative courts, as was also mentioned this morning, look at, what is the risk of someone being jailed in the country of origin. But we're often, at least from my perspective, courts don't really make a difference if this is someone who has lived in Germany and has found what it means to live openly as an LGBTI person. If that person went back and lived openly or lived in a partnership, how the question of risk then changes. So maybe Alva and then Jonathan, you want to jump in?
Yes, well, I think the court decision you're citing was really important for several reasons. One of them is obviously the discussion that we've been having for a long time around what does it mean to require someone to return to a country and live discreetly, which in that form, of course, courts are not allowed to mandate someone to do anymore, but they are allowed to infer that someone has lived discreetly so far, and they probably will continue to do so, and so they don't spell it out, and they do send people back, kind of just assuming that that will probably fly. And I think in that context, it's really important to think about what that means. And I've read through quite a lot of even just asylum decisions before anyone has even taken them to court and challenged them. And the descriptions of what someone's life would be like if they returned, the expectations for how that would work, really are really terrifying. So to make that clear, often such statements used to refer to, and sometimes still do, you know, how large a country is, and there might be some large metropolitan areas, and someone could, without major issue, just move there and live there. But what they're saying is not, oh, they're large metropolitan areas, they're more tolerant, they're more open, you can go and live your life freely there. It just means there are spaces that are so crowded that you can just be invisible. You can be invisible and you can stay under the radar for the rest of your life. You cannot have partnerships. You have one foot in jail or worse every time you meet someone for a date. You cannot have children. You have to fear for your housing, your work. You have to probably take on a new name because in many cases your family name is very easily traceable. So these are not, this doesn't just mean, oh, you know, live life as a queer or a trans person, just kind of don't be too colorful when you stand at the bus stop. It literally means hide for the rest of your life. And obviously that is a horrible idea. Please do not require people to do that. The other thing that was really important to me to point out about the decision that you cited is that this was about a bisexual man, or at least that's the way that the court frames it. And in my experience, we are slowly moving towards more courts understanding what things might be like for what they imagine a gay or a lesbian person to be like, or even a binary trans person's life to be like. But there's still a real lack of understanding of all queer and trans identities that aren't binary and aren't clear-cut and are more fluid. And while legal texts and provisions, they do, you know, they list LGBTQ people, for instance, but that B is often not really filled with content and meaning and understanding. And in many cases, there's still an assumption that, well, if you are what a Western European imagines as a gay person, well then obviously living a gay lifestyle is the only option you truly have, so we must protect that. But if you are a bisexual, a queer person, a pansexual person, a polysexual person, or even someone who says, well, I can't really handle those labels, they don't make sense in my language, they don't make sense in my culture, but I am attracted to people of different genders. I think in those cases, it's still much easier to discount someone's story and to say, well, you have different options. And we're not asking you to forego all of your options, just half of your options. And I think we really need to make sure that there's a much, much better understanding of more fluid identities, of less binary identities, and to make sure that we're protecting those people as well.
Thank you, Alva. Jonathan.
Well, from a lawyer's point of view, it's just wonderful that we now have something from the national jurisdiction to which we can refer in the ongoing proceedings. That's really good because, like you mentioned before, this was really difficult to refer to the decision of the CGEU from 2013. So that's good. I just recently sent my first letter to the court using this decision. So, well, that's a good thing. And apart from that, it will be very exciting to see what the administrative courts and higher administrative courts will do with the decision from the Constitutional Court in the upcoming months. I hope that because the decision was that clear, we don't have. I hope that it won't be that easy anymore for judges in administrative courts to say that a secret life is a serious option. So, well, I'm optimistic, and we'll see what the next month will bring.
Thank you, Jonathan.
And
yeah, and I would just
the two other panelists wrote a really nice article about it in Asyl Magazine. So,
yeah, and we will post it on the website for the conference once we're allowed to, because right now it's still under copyright, but we'll make it public.
Another commercial break.
Yeah.
Yeah, and I'm going to put one very specific question to Jonathan, but I'll tie it in with the Constitutional Court, because what was very interesting is that after not ruling on, queer asylum, both the Federal Administrative Court and the German Constitutional Court actually had two decisions within a very short time span, because in December, they ruled on the case of someone who had come not as an unaccompanied minor, but as a minor to Germany. And then the family got rejected, and that person later on, after coming out as an adult, made a second application, where also people from the UK talked about these new second asylum applications, how complicated they are. And a court in Brandenburg, even in the I procedure, in the very quick procedure, they did not even fully address the question of whether Pakistan is safe for gay people, gay men. And the German Constitutional Court said that they cannot, in this Eilbeschluss, in the urgent decision, make the determination, but they have to have a proper procedure that's not just written like the urgent appeal, but actually with an oral hearing, etc. And this is something that also applies not only on LGBT issues, is more important in general and not just for Pakistan. But what was interesting, that of course, if it is people who come here as minors and they're with their parents, then it's very difficult for them to raise the issue. But someone had also asked the question to Jonathan, if there is someone who is a minor but is here as an unaccompanied minor and then being assisted by German social services, etc., whether you have experience if someone is already raising the issue of being LGBTI in their first asylum procedure as an unaccompanied minor.
Well, yeah, the decision you cited is interesting, especially because you can read it in a way that says, okay, it's not really, it doesn't kill your case when you did mention your homosexuality right away. And that is something which will be really interesting to see in the upcoming months as well. How quite often that people don't feel secure enough to tell right away about their sexual orientation. So it's very good to have this decision on our side right now. I'm happy about that. Regarding the question about unaccompanied minors, well, yes, we see that, and of course this raises other problems, because when you come as an unaccompanied minor, sorry, you get a guardian, and you have to talk to your guardian, and this makes it really difficult, because before you came, you probably heard from several people that it's not a good idea to tell your real story to the first person you meet and who asks you about your case. So it is very difficult to develop some kind of trust, so you can tell your whole story. But if you don't tell your guardian or the lawyer who the guardian asks to help, then it's really difficult to bring your sexual orientation in the procedure afterwards. So of course, it is always better to tell it right away, and not to wait for the first rejection or the second rejection and then bring it up 3 years later. But that's easy said, for many people it is very difficult, and for those who can't tell it right away, the decision you quoted is is a very good one.
Okay. Thank you, Jonathan. Yeah, we are going to go a little bit over time, since we also got some very interesting questions, including regarding COVID. So, I mean, we heard a lot today about the problems people are having, and also people are having problems contacting counseling, contacting lawyers, communicating with the courts. But I did want to bring up two quite specific questions. And one, maybe Jonathan can address, that is that the European Commission has put out a document, a communication, where they are quite explicitly saying that if someone is here in the Dublin procedure and there are no court cases, etc. involved, and there's that 6 months rule, that there will not be a break, that there will be no extension of this period due to the COVID crisis, where there are no transfers right now. But the German Federal Ministry of the Interior and BAMF are thinking that they can do legal hair splitting and saying that it just gets interrupted and then the clock starts again. So this is one issue that I would really address in the context of COVID-19, and the other, which is where Unbit and other people were, talking about all the issues in camps, and, even to the extent that in one case in Ellwangen, more than 200 people got infected, that there are now 2 court decisions from Saxony, from Leipzig and Dresden, where courts ruled that it is in contravention of the regulations around COVID that are, published by the states, that we are supposed to keep more than 1.5 meters social distance, and there was someone living in a 4 square meter room with someone else, that this person should be allowed to leave the camp. And there's been a similar decision, so that the courts will also start looking at that. So that if you, Jonathan and Alva, want to especially address those issues. Thank you.
Should I start?
Yeah.
Right. I'll start with the Commission, with the dispute between the Commission and Germany. I think it is really bad that Germany is trying to prevent Dublin deadlines from expiring. That is a terrible signal that is being sent out there to the people sitting in the accommodation facilities and waiting for clarity on their cases. Those people, they deserve to know what's going on. And it's impossible to know what's going on when the federal office is using tricks to push its responsibility away. People are simply left in the dark. And in addition to that, I think it's wrong from a legal point of view. Basically, I think it's wrong for 2 reasons. First, because there is no possibility in the Dublin regulation of suspending time limits, at least as Germany would like to do it. The Commission was fortunately quite clear on this point. One central aim of the Dublin regulation is to speed up procedures and provide clarity for people. This will not work if national authorities can suspend deadlines whenever they want, whenever it suits them. To show how clear the Dublin regulation is on that, you can just read preamble point number 5, where it says, I quote, it should in particular make it possible to determine rapidly the member state responsible so as to guarantee effective access to the procedures for granting international protection and not to compromise the objective of the rapid processing of applications for international protection. This is crystal clear, really. So it's very I think it's impossible to argument against that. Second argument why I think the German action is wrong from a legal point of view is that the federal office relies on a decision of the Federal Administrative Court to justify its action. But this decision of the Federal Administrative Court places very, very, very high demands on such a procedure. So the Federal Administrative Court said, I'll try to make it short because it's quite special. The Federal Administrative Court said that a suspension should not be a misuse of law. I hope that's the right translation, missbräuchlich in German. And I think that the suspension of deadlines, like Germany is trying to do it right now, is for sure an abuse and a misuse of law, because it leaves people in the dark and is based exclusively on something for which the persons affected by the suspension are certainly not at all responsible. So to sum it up, I think the federal office action is really frustrating. Because the tricks now being used mean that people have to go to court to get their rights in every individual case, which produces a lot of work and leaves them in the dark, leaves often traumatized people in the dark, which is bad, of course, and which is very difficult, especially in times of COVID, because they don't have access to legal advice. Well, and there was a second part of your question.
Around Saxony, yeah.
We all know, and I guess this came up in the other panels already. At the moment, advice centers work to a limited extent. Law firms work to a limited extent. That greatly reduces the possibility of access to legal advice, which is very bad, especially because of the short deadlines that we have in the asylum law. And in addition to that, there are very obvious problems, like you just mentioned, such as narrow distances in the accommodation facilities, and it is impossible for the people in those facilities to keep a distance between each other. And I think that's first of all, that's horrible, and secondly, it's interesting because both the lack of access to legal aid and the lack of keeping a distance from other people are problems that we have since politicians came up with the idea of setting up gigantic accommodation facilities. So now with Corona, it is even more obvious how bad this gigantic accommodation facilities are. Well, thank you for nothing, Horst. It was just a really bad idea to set them up in the first place, and now it gets completely obvious.
Thank you, Jonathan. Well, I would just add before we come to Alva that in terms of the Dublin, I mean, there is the provision that if the asylum seeker does something that legally merits that, the 6 months can be extended to 18 months. But I mean, there's nothing that the asylum seeker has done to cause COVID. So in a sense, it's very strange that then suddenly there is this third option. Well, Alva, if you can just address this before we come to a few of the questions.
Yes, I'll keep it very brief. I obviously agree with everything Jonathan said. All of the problems that we are thinking of in terms of accommodation, specifically with COVID and a risk of infection, were already problems before. It's now that just they have very visible physical symptoms, but that's just another consequence of a lack of being able to have privacy, to have your own space, and all of those things were already massive issues for all people staying in accommodation facilities, but obviously specifically for very vulnerable groups. They're all being exacerbated now, obviously by the risk of infection, obviously by the lack of access to social contact, to specific legal and social counseling, but also by the fact that, at least in North Rhine-Westphalia, we've been told that a lot of the accommodation facilities actually have now upped their capacity to take in even more people. So they're actually getting more crowded in some instances than they have been in the past. And also, this is also specific to North Rhine-Westphalia, we learned at the beginning of this year, before we really knew what was going to happen with COVID and that this was going to have such a massive impact on us, we learned that there's also the decision to segregate accommodation facilities according to nationality and ethnicity. And I think that was intended to streamline staff and services, because that way, if you have people that speak a smaller variety of languages, say, then you have to cover less of those skills with the staff that you're providing around the clock. So it's a very, from an administrative perspective, that is a fiscally wise idea to have. And obviously for the people staying in the accommodation facilities, it's a catastrophe, because particularly for those people, such as queer and trans people, who often say that their journey is not over when they arrive in a camp. Their journey is over at the earliest point when they arrive in individual accommodation, because that's the first time that they won't constantly be surrounded by people from the exact same cultural context that they fled from. For those people, the situation is being exacerbated even more by now potentially being surrounded by almost exclusively staff from that cultural context and language context as well. So that raises questions about, is there going to be staff that discriminates further or refuses to assist people in this context? Say if someone has biases and has prejudice, maybe they will make even less of an effort to provide a queer or a trans person with a room with less flatmates, roommates. We don't know. Is there going to be even less of a chance of people getting fast access to support that is available? We don't know.
Thank you,
we
Alva.
just don't know.
Well, I wanted to, before we come to a final round with some questions that are now quite specific to the situation with COVID, I wanted to thank all the people that sent in questions, and I think Minja will agree with me that we can take some of these questions and take them for the conference in September or whenever it happens, so that we can address more perspectives on the question of taking legal appeals. And, and it would be great if we can have someone from a court join this discussion, and perhaps we can even get someone from BAMF to give their perspective. So there's one question I think that's important, that someone has friends or experience that people who are still in the asylum procedure, either waiting for the hearing or waiting for the court case, that they get letters from the police saying that they are staying illegally in Germany, but I think that the letters probably say that they have entered Germany illegally, because we've seen quite a few cases where people, for example, that came with tourist visa, where later it was said, well, that they made a wrong declaration getting a tourist visa, and then there can be these kinds of procedures. So maybe that's something that Jonathan can address. But of course, people getting this kind of letter in the current situation with COVID can be a bit even more frightening. And there is the general questions, and maybe Jonathan can address that these directives, for example, since Monday, to put on masks in public transport and potentially paying fines or getting arrested, whether this is really a kind of law in Germany. I mean, there have been some court cases today, according to the press, where lower courts have upheld these requirements to wear a mask in public transport to also protect other people. And there is a question about whether it would be possible for not just one person, but several people in a specific refugee camp to take a court case against these crime conditions, like what in Germany would be called Sammelklage. So maybe Jonathan, if you can address these issues, and then if Alva wants to add something, so we can then come to a very interesting session.
Well, I can at least try. About the letters, obviously I haven't seen them. I would guess this, like Philipp, that those are letters saying that people enter Germany illegally. If it's written in these letters that people are staying illegally, well, it's really difficult to answer it in here, because if you haven't seen the letters, it's really difficult to say something about it. In general, if you receive a letter where German authorities tell you that you're illegally here, you should definitely seek for advice. So I would be a bit careful giving a general answer to that. I think that's too dangerous.
Jonathan, I might just add, and sometimes also mistakes are made. I mean, here in the church, we had someone who was clearly in the asylum procedure who for weeks and months had a Duldung, and it took the authorities forever to change it back to the Aufenthaltsgestattung. So, I mean, but you're right that you need to look at the concrete letter.
Someone needs to look at the letter and needs to check in which situation the person is who received the letter. There are various options what this letter might mean. So I really want to be careful with giving a general answer.
Okay, thank you.
Quite typical answer from a lawyer, I guess.
Yeah.
Challenging the rules like wearing masks and stuff. Well, yes, of course. That's really interesting. What's going on at the moment in the jurisdiction? People are trying to challenge the several rulings of the countries. So I think every different ruling has to be checked. Every ruling is a really intense way of like going into the lives of us, of each person in the country at the moment. So I think it's important that people try to challenge those rules, of course. And as far as I can see, you shouldn't be too optimistic about winning those cases. What we saw in the first few weeks when COVID started was that courts were really well staying back and saying that pretty much everything was okay, what the legislator did. But I think this is going to change, because even courts will recognize, will notice that you can't put up all the restrictions for such a long time. So I think there will be a lot of jurisdiction within the next few months about all those rulings. So that's going to be interesting. Yeah, but the short answer would be yes, of course, you can do something against it. And the third question, well, I think that's difficult because it has to be someone who is affected by a specific ruling. So this person has to try to challenge the ruling, and this has to be one specific person. And of course, you can put as an argumentation into your file, into your case, that many people are affected by a ruling, but there has to be one person to bring it forward to the court.
Okay, thank you, Alva. You want to add?
Yes.
Last topic.
Yes, well, maybe just on the question of receiving a letter that the person who asked the question described. I too don't know what that letter is, and I agree that it's really important to have someone look at that letter. There are various things that could have happened. It could be a mistake, it could be a misunderstanding of what the letter says, but there are definitely also instances in which that letter could genuinely say that. So there are cases, if I understand correctly, where someone might be in an accelerated asylum procedure because they're from something that is defined as a safe country of origin, even though that country might have legal penalties for LGBTQ people. And if they're in an accelerated procedure and they get rejected and they appeal that decision, it's still possible for them to be deported, even though that appeal is still pending. That is possible. So it's very much possible for queer and trans people to basically still be in the middle of their asylum procedure, to still be challenging a claim, and for them to still receive a letter like that, and for that to not be a misunderstanding.
Thank you. Yeah, so thank you, Jonathan and Alva, for a very informative discussion. And like I said, the questions that we got that also talk about issues around, language competence or how people get perceived as LGBT, will take those for the upcoming conference. And, I want to thank Menja and the whole organizing team for organizing today. And thank Knut and Muhammad for being there to support with this conference, also with this panel. And I do want to wish everyone here that they can stay safe, that they, to the extent possible, can protect themselves and others. And I do hope to be able to see and meet many of you when we're having the upcoming Sobika conference. So really thank for everyone who helped putting this together, and thank Alva and Jonathan, and have a nice day.